Hello and welcome to BLG's update for charities and not-for-profits, dealing with organizations in the time of COVID-19. My name is Victoria Prince, and it is my privilege to chair the Charities and Not-for-Profit group at BLG. Today, several knowledge experts will be sharing information on how to continue to be compliant in a world facing a pandemic. There are many topics that we could be addressing, and we hope to make these kinds of updates a more regular occurrence. So please reach out to us with specific items that might be of interest to you. Today, we are going to look at corporate compliance, dealing with contractual issues, the myriad of employment challenges being faced, and what we can look forward to as we move beyond our current temporary new normal. Specifically, will collaborations and restructurings become more prevalent? A quick reminder that there are many resources on COVID-19 related topics and legal matters more generally on our website. As well, there are lawyers in each of our offices, Vancouver, Calgary, Montreal, Ottawa, and Toronto, willing and able to assist on these and other important topics. I am delighted to introduce Sylvie Lalonde, an experienced and amazing charities and not-for-profit lawyer in our Ottawa office. Sylvie has a broad corporate practice within the not-for-profit sector and acts as an outside general counsel for several clients. She advises not-for-profit organizations and charities on a wide range of issues, including corporate governance, transactions, incorporations, charitable registrations, and drafting of agreements. Fluent in both French and English, Sylvie provides services to our clients in both official languages. Sylvie is going to talk with us today about governance issues and corporate matters during COVID-19, including filing and meeting requirements nationally and virtual meetings. Quite a few things that are important to organizations and about which we have been receiving many questions. I know that one of the things people have been asking is whether the board's objectives need to be reassessed in light of everything that is going on. Sylvie, is that something you could address for us?
Yes, absolutely. Thanks, Victoria. So some organizations will be impacted more than others by the pandemic. A key role of the board during this time is assessing the impact of COVID-19 on the organization and resetting its priorities. The board should defer all board work that is either not related to supporting the organization through the COVID-19 crisis or not critical to the long-term success and sustainability of the organization. Directors should be looking at the board and committee's annual work plans and ask what is mission critical in the next 30 to 60 days and what can be deferred. Directors should focus on where they can add value and be agile and responsive while at the same time minimizing any unnecessary burden on management. Some of the board's key priorities during this time might include the following: ensuring the physical and mental well-being of its employees, as this will best ensure the organization delivers on its mission and purposes. The board should also be making mission-critical decisions that require a board decision in the most efficient manner possible, such as decisions to support the availability of resources, both human and physical. The board should also be ensuring that there are succession plans in place for key leadership roles, including board leaders, to cover a temporary or unexpected absence. The board should also make sure that management is reducing resources required to support the board and its committees. During these challenging times, the value the board brings to the organization must outweigh the costs of supporting the board, both in terms of management's time and energy. And finally, the board should ensure that any organizational plan to manage the crisis, including any plan to gradually reopen or ramp up operations, complies with applicable legislation and governmental directives. Although organizations share a great number of challenges during this time, each of them will experience their own unique obstacles, and their boards will need to adjust their priorities based on the specific situation and circumstances of their own organization.
Thanks, Sylvie. That's a great overview. Do you think boards should be reconsidering how they conduct business?
I think they have to. The board and its committees will likely not be meeting in person. In fact, the directors should be asking themselves whether they need to be meeting at all. There is no prescribed number of board meetings that must be held annually, but the organization's bylaws might require a minimum number of meetings per year, so those should be consulted. The board might be able to suspend its regular meeting schedule for the duration of the emergency if there are no mission-critical decisions or important board oversight roles required to be performed during the anticipated length of the emergency. In this time of crisis, organizations might have trouble reaching quorum for a meeting of the board in a timely manner. To address that, the board could consider delegating some or even all of its powers to an executive committee. But not all boards have an executive committee, but the bylaws might allow the board to appoint one and delegate its decision-making authority to it. Applicable legislation should also be consulted. For example, if the Corporations Act of Ontario applies to your organization, the board can't establish an executive committee unless the bylaws allow the board to do so. If the organization is incorporated under the Canada Not-for-Profit Corporations Act, which I will refer to as the CNCA, the limits on the authority of the executive committee must be taken into consideration. So, for example, an executive committee can't fill board vacancies, approve financial statements, or adopt amendments to the bylaws. If a board decision is required on short notice during the crisis, consider if it can be made by an executive committee or if the full board is really required. Now, I know that many boards have a concern that an executive committee leads to a board within a board, and they might be reluctant to establish such a committee. To address this concern, you should consider calling an electronic meeting of the full board and notifying the directors that if quorum is not achieved, but there is a quorum present for an executive committee, the meeting will proceed as an executive committee meeting. However, all available directors will be allowed to and encouraged to participate in the meeting, but only the members of the executive committee could vote. This will give management the benefit of a wider range of views while allowing prompt and timely decisions to be made. The agenda for such a meeting should also be limited to the critical business at hand. For example, the minutes of the last meeting of the board or the executive committee can be approved at a later date. And finally, remind board members that these are temporary measures and that the executive committee can be a time-limited committee. Another decision-making tool to keep in mind is a resolution in writing in lieu of a meeting of directors. So if a decision is required and it is not possible to call a board meeting, a resolution in writing that is signed by all of the directors may substitute for a board meeting. But the resolution must be unanimous, and each and every director in office must sign the resolution in order for it to be valid. Of course, if board members are not immediately available to sign the resolution, then this is not likely a practical way to get a decision made quickly.
Thanks for that, Sylvie. Those are some great practical and useful tips for our listeners, and I think really important overview of some key issues. One thing we've received a lot of questions about is if and how meetings can be held other than in person, the old-fashioned way. Can you discuss that with us?
Yeah, absolutely. We have been receiving a lot of questions on this particular point. So first, we'll talk a little bit about the requirements for a board meeting. So as a general rule, applicable legislation in the organization's bylaws will dictate whether or not a board meeting can be held, either by teleconference or other electronic means. For example, under both the CNCA and the Ontario Corporations Act, a board meeting can be held electronically if all of the directors consent, unless, of course, the bylaws provide otherwise. In some jurisdictions, emergency orders have been issued to specifically allow boards to hold electronic meetings, regardless of what the governing statutes or the bylaws of the organization say. For example, on March 30th, 2020, a regulation was issued under the Emergency Management and Civil Protection Act of Ontario that allows electronic meetings for the board of directors of organizations to which the Corporations Act applies. And again, that's regardless of whether or not the letters patent or the bylaws allow it. The emergency order also dispenses with the requirement that all directors must consent to holding a board meeting by such means. Similarly, in Alberta, a ministerial order was issued on April 9th, 2020, under the Public Health Act of Alberta. That order suspends all obligations to convene an in-person meeting under the Companies Act and provides that nothing precludes an organization from holding a meeting remotely. For organizations incorporated under the CNCA, The general rule continues to apply, and no similar emergency orders or regulations have been enacted. So again, if the bylaws allow for a board meeting to be held electronically for a CNCA corporation, then those organizations are good to go. And so now I'll take a quick look at what are the rules for meetings of members held electronically. In Ontario, it's unlikely that at the moment an in-person annual meeting of more than 5 people can be held legally during the COVID-19 crisis. If the organization is governed by the Ontario Corporations Act, the emergency order referred to earlier authorizes corporations to hold a meeting of members, including the AGM, electronically, despite anything to the contrary in the letters patent, bylaws, or other applicable legislation. Again, in Alberta, the ministerial order mentioned a few moments ago suspends the requirement that an AGM of a not-for-profit must be held in person. Instead, the order permits organizations under Part 9 of the Companies Act to hold a meeting of members through electronic means, regardless of any provision to the contrary in the organization's Articles of Association. No similar emergency legislation regarding electronic meetings has been issued for organizations incorporated under the CNCA. And again, this is with respect to members' meetings. However, the bylaws of a federally incorporated organization may already allow meetings of members to be held entirely by electronic means. If they do not, then the board might be able to amend the corporation's bylaws accordingly, with the change becoming effective upon adoption of the board and remaining in effect until the next meeting of members, where the change can be confirmed or rejected by the members. It is important to note that a meeting of directors or members is still required to have all of the formalities of an in-person meeting. These include proper notice of the meeting, achieving quorum, and the taking of minutes. Presence should be taken, and the procedures for proposing and seconding motions should also be followed, and voting rules and procedures will also be in effect as usual.
And a quick reminder for our listeners in jurisdictions other than those that Sylvie has specifically mentioned, and of course we don't have time for her to go through every one, we do have updated information by jurisdiction on our BLG website, on our COVID resource site. So if you want to look at that, and it is updated quite regularly as these emergency orders get shifted. Sylvia, a specific question for you. You talked about the ability to have electronic meetings in some jurisdictions, for example, regardless of what your bylaws say. What about the timing of annual meetings? I know we have had a lot of clients that have had concerns because their annual meetings would ordinarily fall within this period of time we're in right now. What can they do about that?
Yeah, that's a great question. Although organizations can hold meetings electronically, many of our clients have large memberships and would prefer to meet in person, or perhaps they just don't have the infrastructure or the technology to hold an AGM virtually. And so in some jurisdictions, the organization may be allowed to postpone the date of their AGM. In Ontario, for example, organizations that are subject to the Corporations Act of Ontario are still expected to hold their AGM no later than 18 months after they've been incorporated, and subsequently not more than 15 months after the holding of their last AGM. However, pursuant to the emergency order, an Ontario not-for-profit will be granted a 90-day, or in some circumstances, a 120-day extension from the date upon which the emergency is terminated, if the normal time frame to hold its AGM falls within the period of the declared emergency or in the 30 days after the emergency is terminated. There is no need to apply for this extension. An organization that meets the criteria can simply defer its AGM in accordance with the applicable time frame. Under the CNCA, federal corporations must hold their AGM within 6 months of their financial year end. As previously mentioned, no emergency legislation similar to Ontario has been issued federally. However, on May 12, 2020, Corporations Canada published additional guidance for federal not-for-profit organizations during COVID-19, which includes a new link to a simple online application form for corporations who want to delay calling their AGM. Organizations can use the simplified form if they are unable to comply with the timelines established by the Act due to COVID-19 circumstances, and if extending the time for calling an AGM would cause little or no prejudice to its members. The application form provides that you must apply for the extension at least 30 business days before the date on which you would send the notice of AGM to your members under normal circumstances. If the extension is approved, the organization must inform its members of the extension not later than 60 days after the exemption has been granted, and it must call its AGM before October 31st, 2020, and hold the AGM before December 31st, 2020. The simplified application form must not be used, however, to request a delay for reasons that are unrelated to COVID-19. If a federal corporation wants to delay its AGM for other reasons, it must follow the usual Section 160 application process, as set out in Corporation Canada's policy on extending the time for calling an AGM. It should also be noted that the AGM extensions granted under both the Ontario Emergency Order and the federal application also provide relief with respect to the requirement that the financial statements presented to the members at the AGM must cover the period that begins at the end of the last completed financial year and ends not more than 6 months before the AGM. Instead, the financial statements to be presented at any postponed AGM will be the financial statements for the year ending on the most recent financial year end. So finally, I just wanted to mention briefly a couple of other extensions that have been granted as a result of COVID-19 for the filing of certain forms. Federally incorporated not-for-profit organization whose anniversary date is between February 1st and June 30th now have until September 30th, 2020 to file their annual return. Normally, corporations are required to file this annual return within 60 days of their anniversary date. If your organization is incorporated provincially, you should consult applicable legislation and governmental directives to see if any similar extensions have been granted for filing provincial annual returns. And finally, if your organization is a registered charity, the filing deadline has been extended to December 31st, 2020 for all organizations with a T3010 due date between March 18th, 2020 and December 31st, 2020.
Thank you again, Sylvie. That was great. Thanks for that informative and interesting presentation. These are really important issues for our listeners, and we very much appreciate you providing us with the level of detail you did.
Thanks very much for having me.
A topic that has been raising issues since the very beginning of this crisis has to do with the ability to cancel a contract or postpone it or rely on a force majeure clause. How can you deal with conference bookings? What if you no longer need those items you ordered as marketing handouts? Our colleagues in the disputes group have been answering many questions like these for a wide range of clients, including those in the not-for-profit sector. Today, Hugh Mean will give us an overview of the key elements of the law and provide some insights on what to look for as we move forward. Hugh specializes in international commercial investment and construction arbitration in a range of industry sectors. He also focuses on investment protection disputes arising under investment protection laws and treaties. He's indeed a lovely individual with whom to work, and happily for our program today, Hugh also knows a great deal about the doctrines of frustration and force majeure. Hugh, could you start by giving us a bit of an overview of what is meant by the terms frustration and force majeure?
Thank you, Victoria, and I would be happy to touch on those topics. In fact, it's the first topic that I intended to speak to you about today. But I'd also like to look at how these concepts can operate in practice, and then make a few comments about how the legal concepts of force majeure and frustration may be relevant to not-for-profits in particular and circumstances that they may be currently facing. So if we deal with that first question of what are these concepts of force majeure and frustration, the key point to know is that they have some relationship, but they do different things, and they have different forms and treatment in law. A force majeure clause is a term in a contract that has been negotiated and agreed, or if not negotiated, certainly taken from some pre-existing language by the parties and inserted into a contract that is then intended to be performed by the parties. A force majeure clause relates to specific circumstances or events that have been enumerated. that cause the parties to be unable to perform their contractual obligations. So the specific circumstances are normally enumerated in the clause and often deal with things like natural disasters, riots, acts of terrorism, or other events that are outside the control of the parties. But really, it's at the liberty of the parties to define exactly what types of events and circumstances constitute force majeure. These force majeure clauses typically operate to excuse performance of specific contractual obligations for a period of time, and may even ultimately result in the release of the parties from those obligations if the inability to perform carries on for a specific duration of time. The important thing to know is that there can be considerable variance in terms of the effect of the clauses and how long they may apply to the parties. Really, it's driven by the drafting of the clause in particular. And though there are some themes that tend to repeat across force majeure clauses, it's always important to look carefully at what the clause actually says. Frustration, as I mentioned, is related. However, it's actually a concept of law that it develops in the common law. So in that regard, it will apply to contractual obligations and parties to a contract, irrespective of how they may have drafted their force majeure clauses or whether they've included one at all. Frustration deals with supervening and unforeseeable events that make performance of the contract impossible. So in this regard, the circumstances under which the parties intended to perform their obligations have changed radically, and they can no longer perform those obligations. Generally speaking, concepts of impossibility, unforeseeability, and the fact that the events are supervening make frustration quite a high bar for parties to reach in order to release themselves from the contract. Frustration is also notable because the result of applying the doctrine is that the contracts are terminated. In other words, unlike some force majeure clauses, which merely suspend performance for a period of time, the doctrine of frustration, if applied to a particular circumstance, will terminate the contract in its entirety. So to continue on slide 2, we turn now to how these concepts, force majeure and frustration, may apply in practice. And whether a force majeure or frustration event has arisen needs to be considered in the facts that are facing the parties. And on this slide, there are 5 steps in general terms that are listed out as to how a party might determine whether or not force majeure applies to them or frustration, and how they may go about asserting that particular position. The first step is to define the event. And again, it's important to understand exactly what it is, the circumstance or the event that a party identifies as being the issue that prevents it from performing. It may be, in the context of COVID-19 specifically, the pandemic in general terms, or it may actually be flight cancellations that arise from the pandemic or other forms of self-isolation or social distancing that makes the performance of the obligations no longer possible. Once the event has been defined, it's necessary to determine whether or not the event is actually applicable to the contractual obligations that need to be performed. And this is important because not all events, say relating to the pandemic, affect all obligations that a party may need to perform under a contract. It's not enough to simply say there's a pandemic happening now, and for that reason, I will not be able to perform my obligations. It's important to understand exactly how the pandemic might affect the obligations that are at issue in a contract. Third, and I think this is always important for parties to consider, is whether or not there's alternative relief that's available to parties aside from invoking a force majeure clause or declaring frustration of the contract. Often, agreements between parties have other provisions relating to delay or circumstances that may change the intended operation of the obligations that may serve the parties exactly appropriately in the circumstances rather than a force majeure clause. In addition,
I'm going to pause you there. Sorry, my apologies. I just wondered, this is a question we've been being asked a lot, and you mentioned there might be other relief available. Are you able to elaborate on that a little bit?
Yes. So I think there's two ways to look at it. One is, what is the alternative relief within the contract? Are there other terms that give some form of flexibility or some form of alternative option to parties to resolve a delay question or an inability to perform a particular obligation without going to the more substantial remedies of force majeure and particularly frustration? So the first way to look at it is what else is available in the contract. The second way to look at it is to consider what can we do with this counterparty that we have in order to resolve our challenges. Very often there's a solution that exists outside of the contract that can be achieved through discussion, negotiation, and some compromise over how things will go forward. To take the example of hotel bookings, sometimes parties may not want to use the hotel booking in 2020 because of the cancellations and difficulty in travel that is currently facing us, but there is an ongoing interest to have an event in the future. And that can be a point of agreement and resolution for the parties rather than simply invoking force majeure. So I think you always have to look at that particular question both within the contract and outside. That being said, if the parties are intending to, I should say if one of the parties is still intending to invoke the force majeure clause, it's important then as step 4 to consider whether there are notice requirements or specific procedural steps that are required in order to do that properly. And then finally, upon invoking the clause for force majeure or declaring frustration of the contract, a party that is doing so should consider what mitigation efforts still can be undertaken. And in this regard, what we're referring to is performance of remaining contract obligations or steps that can be taken to minimize the costs to the both parties as a result of the circumstances that have arisen and make performance of the contract impossible.
That's extremely helpful. I find this topic fascinating, to be honest. I think I've heard the words force majeure more in the last 3 months than I have in the 10 years put together before that. Question for you: what can our charity and not-for-profit clients consider going forward as they're dealing with COVID-19 in terms of your topic?
Well, Victoria, I think the first, there's a few things that all parties can do, and particularly those in the not-for-profit sector. First, and these relate to some of the points that I've raised already, is to consider what legal rights a party may have under existing contracts and what forms of relief may be available to them within those contracts. Next, if there is a dispute, it's important to develop a strategy. And as I mentioned, this may be actually not a strategy that involves the time and the costs of formal litigation or arbitration, but it might involve some of the more balanced costs of mediation or something even more informal in terms of negotiation that can result in a solution without resorting to formal legal procedures. Once that is completed, parties can then implement that strategy and should do so with a consistent and responsive communication plan. Going forward, it's important that any new agreements that parties consider with new counterparties relating to new projects or initiatives, just as you mentioned, Victoria, it's been a long time since there's been this much discussion of force majeure. What that means is that a lot of the language that was formally included in standard force majeure clauses needs to be examined very carefully, because now the issues relating to COVID-19 are very much known to contracting parties in Canada and elsewhere around the world, and may no longer qualify for the type of unforeseeable events that would previously have qualified for force majeure or frustration. So for that reason, going forward, in order to protect their position and the proper operation of force majeure clauses in the way the parties intended, they should be very careful to ensure that COVID-19 events are covered by force majeure clauses, and that they intend to continue to use events that are related to COVID-19 as potentially affecting or modifying the contractual obligations that they undertake, so that no one is caught by surprise when this particular pandemic evolves and may cause further problems for performance in the future.
Thanks you. That's very helpful. And I think that last comment you made is critically important for our clients. And I think another comment would be, we need to be careful of not just taking a force majeure clause from one contract and putting it into another one, because as you mentioned in your earlier comments, there are nuances and subtleties to this that our clients need to be available. As always, we appreciate your knowledge and guidance, and I think we will be hearing from you again on this topic one way or another. We will now turn to the world of employment. James Fu, a partner in our Labor and Employment Group, is going to discuss employment matters and wage subsidies. James has a multifaceted human resources law practice, handling day-to-day litigation and corporate transactions mandates for clients in both pension and benefits and labor and employment matters. James has been immersed in issues around COVID since it first came to our attention. James, there have been a number of government support programs that have been announced by various governments in Canada, some focused on the employer-employee relationship. I have heard it called an alphabet soup of programs. Can you provide us with a brief overview of some of the government support programs, particularly for those that directly relate to employees?
Once again, there have been a lot, so I'll focus on a few of them. The first one is the Canada Emergency Wage Subsidy. Now, this program is on the minds of a lot of clients and businesses in general. Now, non-for-profits and charities are contemplated to be eligible employers in the Canada Emergency Wage Subsidy program, provided the other conditions of the program are met. There are time limits and some other considerations for applying, so organizations should make sure to apply at the right time, and also having considered all the relevant factors, including any retroactive recalls of staff. Now, separately, there is the temporary 10% wage subsidy. The temporary 10% wage subsidy program is a measure that allows eligible employers to reduce the amount of payroll deductions required to be remitted to the CRA. Now, again, in this case, non-for-profits and charities are contemplated to be eligible employers, once again, provided the other conditions of this temporary 10% wage subsidy program are met. Now, the federal government has also extended the maximum duration of the work sharing program from 38 weeks to 76 weeks for employers affected by COVID-19. There are also a number of other programs, such as the temporary wage top-up for low-income essential workers. There's also the temporary changes that have been announced to the Canada Summer Jobs programs. There are also other non-employment, necessarily employment programs. They include the Canada Emergency Business Account, the Canada Emergency Commercial Rent Assistance Program, and the CERB. And suffice it to say, there are a number of programs, exactly alphabet soup, and organizations should explore each one that they may be eligible for.
Thanks for that overview, James. A next key consideration for many not-for-profits and charities will be returning to work. What are some COVID-19 work policies that employers should be considering?
Employers will have the important task of navigating the unique and complex issues related to COVID-19, including the return to work process. Now, a key manner to navigate through that process is to have appropriate COVID-19 related work policies. Some policies to think about include the following. The first one is a risk assessment. It's not a policy per se, but it's more of in the process of assessing the workplace, so categorizing COVID-19 levels and risk levels. The second policy would be, or related to this, would be a return to work policy. And this one, I would generally recommend a robust one. And what I mean by that is, number one, perhaps input from a task force, HR, operations, management, a number of essentially leaders in the organization that can provide input. Now, some of the suggested issues for a return to work, this robust return to work policy, is what do we want the workplace to look like? So, for example, things along the lines of physical distancing and also remote working, teleworking, whether that will become a norm or whether that will become less prevalent in the workplace. New products, whether our organization will be creating new products and what impacts that will have on the workforce. Immediate recalls versus having some employees remain on layoff. Work times, staggering working times, training on return to work issues, and also amending related policies such as travel policies, vacation policies, and, as I alluded to earlier, remote working and also teleworking policies. Other related policies will be related to screening. So that will be an important one for employers when employees come back into the workplace, in the physical workplace. So there are a few different types of screening. There's passive screening and there's active screening. There's also testing, and I'll go over them briefly. So passive screening will be essentially where employees are asked to self-identify if they have symptoms or have been exposed to COVID-19. They're usually considered minimally intrusive. There's the next step of active screening. So this will be questionnaires where employees sign and verify that they do not have symptoms and or have not been exposed to COVID-19 that they're aware of. Now, this is becoming quite common in terms of having questionnaires. Testing, these are emerging issues, and there are three main types of testing. There's diagnostic, which is saliva and nasal swabs. There is antibody testing, so those are blood tests through usually a pinprick of the finger to determine if there are any antibodies. And the third main type of testing now is antigen testing. Now, specific to the workplace, these policies will, these screening policies will be specific to the workplace. We'll have to consider whether it's reasonable in each circumstance to have it. For example, temperature screening might be appropriate, and how long certain screening measures are in place, any privacy issues to be considering, and also human rights potential issues. Now, the key on these types of policies will be to give employees advance notice that this will be implemented, let them be aware what will be happening, what information will be requested to be provided to the employer, and what will happen to that information.
Thanks, James. It sounds like this is an area where, like many, where training and communication is critical. I know we consistently advise clients to have policies in place, and you've just given us a great overview as to why that's important. But why is it so important now to have appropriate work policies regarding COVID-19?
So the first is, the main benefit I see is it sets expectations for employees. So employees will know when they come back into the workplace what measures are being taken, what measures have been taken, and what measures will be taken going forward for a worker's safety, and also what obligations that employees are expected to have. For example, reporting instances of potential exposure to COVID-19. Now, secondly, it allows and focuses organizations' minds on forward planning, on what could happen. So, for example, a policy related to my comments earlier would be what happens if there is a diagnosis or a potential exposure in the workplace of COVID-19. Having a policy in place allows us to forward plan so that we're not reacting on the spot. We have a policy and we can implement it. Now, third, it will likely assist employers in case there are future issues related to COVID-19. So, for example, if there is exposure of COVID-19 in the workplace and there is a health and safety investigation, it will likely assist the employer to have such policies in place to demonstrate that they are taking all reasonable precautions in the circumstances to protect the health and safety of its workers.
Wow, well, it certainly sounds like policies are very important. Now, as you know, because you act for many of them, our not-for-profit and charity clients vary, and some will have employees currently at work, while others will have employees that are either remotely working or on temporary layoff or leave of absence. Are there words of wisdom for those that will be recalling employees to work and how they should deal with work refusals, which can impact those that have maintained operations or those that will be resuming operations? Any words of wisdom gratefully received.
The first word of wisdom would be to have objective and written procedure for recalls, including who, when, and why. And one of the main reasons to do so is there may be complaints or challenges related to who is being recalled. Now, having a objective and written procedure in place allows us to defend against any potential claims. Now, related to that will be the recall notices. So the recall notices, that will be important in terms of having a written one, an appropriately written one to employees. Now, some components in the recall notices to consider is when the employee will be coming back, setting out the work conditions, the consequences for their return, and also if they do not return. Now, one of the issues that we are dealing with, and also that we anticipate will become more to the fore, is refusals to return to work. So how to deal with those? Those ones are not easy to deal with in terms of refusals to return to work. There may be various reasons why an employee is refusing to return to work. It could be, for example, employee obligations to care for a family member, an employee's own illness, an employee's exposure to someone who has COVID-19. It could be directed by public health or a physician for the employee to remain in quarantine or self-isolation. Or the employee may have general feelings or anxiety that the workplace is not safe for them. In each case, it will be a case-by-case basis determination, and employers will need to understand the reason to see if it's justified. So I would suggest a 3-step process. The first step in terms of a work refusal is to gather more information on why the employee is not returning to work. The second step is to assess whether those reasons, to see whether it falls within any protected category or not. So similar to related to the first step, and to actually do the assessment. And then the third step is to deal and or manage with refusals to return to work, making any changes that are appropriate, if there's appropriate. And at the end, if it's determined that it is a safe workplace, then the employer may be justified to take disciplinary measures up to and including termination, or deeming employees to have resigned and are abandoned employment. Now, one thing to keep in mind is that we have to be mindful of reprisal, which is prohibited by health and safety legislation as well as human rights legislation. Now, slowly and surely, we are emerging from weeks of lockdown, and there will be issues as we do so in terms of employment-related issues, and having appropriate policies, including return to work policies, will make that process that much more smoother.
Thank you, James. That has always, you've been insightful and helpful, and I think there is a lot for people to digest, which reminds me, this is a quick reminder that we have many resources available on our website, and in particular, James and his team in the Labor and Employment Group have published many articles, alerts, and bulletins with respect to the issues you are facing during COVID-19, and I would highly recommend looking at those should you have any follow-up questions. And now to Nick Pasquino, a partner in our corporate commercial group, who will talk about key considerations for organizations facing financial difficulty during COVID-19. Nick practices corporate commercial law and serves as a trusted advisor to key clients of the firm. He has been recognized for his practical business and legal advice and for leading teams of professionals to successfully implement large legal projects. Nick has significant expertise handling mergers and acquisitions, financings, joint ventures, partnerships, reorganizations, and divestitures. In recent years, a significant portion of his practice has involved representing large charities, not-for-profits, and other broader public sector organizations on a variety of strategic transactions. And when we are not physically distancing, Nick and I sit beside each other in the office. Nick, over to you to address this interesting and important topic.
Thanks, Victoria. The COVID-19 pandemic has caused unprecedented disruption, and so many organizations are facing unexpected financial pressure. And so questions I've been getting recently have been around what do boards and what do management teams need to do to react quickly yet prudently to navigate these uncharted waters. So the starting point, of course, is let your fiduciary duty be your guide. While every organization will be affected differently by COVID, all boards and all senior management teams have the same fiduciary duty, which continues to apply to their decision-making during and following COVID in the same way it applied before COVID took place. So what is that duty? Everyone has a duty when they're making decisions to act honestly and in good faith with a view to the best interest of the organization you serve. And if someone is watching what you guys are deciding, what standard will they compare you to? And of course, directors must exercise the care, diligence, and skill that a reasonably prudent person would exercise in comparable circumstances. And that would be the standard to which you're compared if somebody was evaluating the quality of your decision-making as a board or senior management, including during COVID-19. So with that guideline, we should look at what are the things that organizations are doing now, and many of you would have already done, to deal with the financial implications of COVID. So the first piece I'd like to talk about are 4 key financial management steps that all relate to a COVID financial plan. The first step is developing the plan. And of course, many of you, when we first got into the crisis, would have looked at and done most of these things already. So analyzing your cash flow, understanding how the impact on revenue and how the impact on costs will impact your organization, and project over the course of the months that we will be hit by COVID, what your cash flow deterioration might look like. Also, in part of your developing the plan aspect of financial management, look at your assets and look at your liabilities to see what is there, what was on track and on budget pre-COVID, and what's expected to be blown out of whack given the implications of the pandemic. Everyone will have new costs that were unexpected. Everyone's assumptions on revenue will be impacted adversely. The second part is to test that plan. And this is where boards can work well with management to make sure that assumptions are properly challenged. And you should be planning for worst case scenario, medium case scenario, and best case scenario in terms of our exit from the pandemic. The other element of testing the plan is to have key elements, the material elements of your plan, looked at through the proper lens with the assistance of the right advisors. I've been getting questions, and BLG's been getting questions from a legal perspective on what are the legal consequences of certain actions. For example, if we have no revenue coming in and we are in default under our leases, what are the implications? And it's one thing for management to read your lease and to talk to your landlord and to come up with a number, but from a board perspective, you may want some additional comfort from a legal review of key material contracts to make sure that the advice you're getting fully takes into account all the various legal elements. And it depends on the complexity of your documents, of course, but those are some of the questions that have come to us.
Nick, you and I know that directors and officers tend to be somewhat concerned about possible personal liability. Are you able to elaborate on when a director might be personally liable for payroll?
Sure. This is a question that often comes up, and to properly answer, you need to do some legal and financial due diligence on the organization. So what I'm going to be saying now is general, and don't take this as definitive legal advice for you, but you've got to start with looking at what corporate jurisdiction the organization exists under. Are you federal? Are you an Ontario entity? And so on and so forth. Then you need to look at the facts on what your financial position is. Does the organization have the assets, whether it's cash or non-cash assets, that could be used to make payroll, or are you in an insolvent position? And then you apply the law to your corporate jurisdiction and those facts. So if we were an Ontario corporation, for example, directors are jointly and severally liable together with the corporation, with the organization, for up to 6 months of wages and 12 months of vacation pay. But that only kicks in if the organization can't pay, which is why the financial due diligence is really important. There's also related questions for directors about personal liability on what we call the withholding and remitting laws. So the Income Tax Act, the laws that govern CPP and EI withholding and contribution, etc. That I won't go into in the example, but that all flows into the due diligence that you'd need to do so that the board feels protected and they know that they have the right plan in place. One of the things that we can look at, for example, is mitigation strategies. What can we do to protect the organization and ensure it's not in a spot where it's going to be insolvent or can't meet the 6 months of wages or 12 months of vacation pay requirement? And what sort of due diligence activities are you doing to make sure that management is telling you that they've properly withheld and remitted CPP and EI? Another consideration when you're looking at the plan is timeframes, short term, medium term, and long term. So, of course, in the short term, it's cash management. Everybody knows cash is king. And so you're going to look at your payables, you're going to look at your receivables, and you're going to see how long of a runway you have, sustain yourself while we try and weather this storm. Second element of testing the plan is more about strategic and operational plan management. How is your operations going to change because of COVID? What are the financial consequences of those changes? And are you able, based on your projected cash flow, able to continue to hit your strategic and operating objectives under the new normal? And of course, the long-term plan, and what I'm going to spend time on at the very end of this presentation, is sustainability of mission. One of your jobs as a board and as senior management is not only to look at the short term, but for the long term, are you setting up your organization for success on a sustainable and ongoing basis to satisfy your mission? Just to finish off these financial management steps, approve and implement the plan. Of course, we are restricted to meeting in person, and so everybody isn't able to meet remotely. And if you need some help on how to do that, you can talk to your friendly legal advisor and they can make sure you're doing it in the correct way. And of course, lastly, tweak the plan. The perfect is the enemy of the possible, which is a quote somebody said on a call a few weeks ago. All we can do is use our reasonable business judgment to build out assumptions and worst, medium, and best case scenarios, and then get on with it. So make sure you're not spending too much time on planning, and make sure you're executing on the plan and then tweaking the plan as you go. That turns to what legal options are people considering from a financial perspective in managing this COVID pandemic. And of course, this list of things is things that everyone on this call has already done, whether it's deliberate and exhaustive or whether it's intuitive, right? The first is working capital management. Have you accelerated your receivables? Have you tried to spread out your payables? This will look different for every organization, but I've seen people who have said, if you pay your membership fees now, we will give you a discount because they need cash in the door. People have been looking to their vendors, and everyone's in the same boat. So they've tried to spread out payment terms by extending them by 30, 60, 90 days. So what can you do to adjust your working capital to meet your needs during this pandemic? The second thing is, from an operations perspective, can you cut new spending? So not delay starting that new project that you had on the books for 2020. Impose freezes on new hiring. And then, of course, the corollary of that is cutting operational spend. People are stopping their marketing spend or reducing their marketing spend and other non-essential expenditures, looking at staff cuts, layoffs, salary cuts. Of course, the corollary of that is access to government relief programs, which is 2 bullets down, renegotiating commitments with your stakeholders. So if you are leasing space, can you get an abatement of rent? Can you get a deferral of rent? Can you do it on a voluntary basis with your landlord? Do you need to participate in the government commercial tenancy relief program to get access to that program? And similarly, with other material contracts, can you renegotiate terms with your suppliers if you don't need the degree of supply because your facilities are closed or opening on reduced capacity? If all of that stuff has happened and you still need to make steps to manage your financial position, people are drawing down on existing credit facilities. Now, the good news is the government has done what they can do to reduce interest rates, and hopefully they stay low to make borrowing sort of preferable terms right now. But people are drawing down on existing lines of credit if they need cash flow assistance. So then that turns to, what are some legal options that you may not have considered? And these are ones that I've had an opportunity to brainstorm with various organizations across the sector, various charities, various not-for-profits, to see if there is different types of ways to unlock value or create solutions that may not be obvious or intuitive at first glance. The first one is unlocking balance sheet value. So this is looking at what assets you have as an organization and considering whether you need to do extraordinary steps to deal with extraordinary circumstances. So what do I mean by that? If you're an organization that happens to operate in, is there a reasonable opportunity for you to sell and lease back that space so you can take that cash and redeploy it into your operations, but continuing to have long-term access to it? Right? Similarly, if you operate on a big parcel or on multiple parcels and you don't need everything for your operations, can you sever and sell a piece of your land? Or if you've got non-core real estate holdings, can you sell them and use the cash and redeploy it for other purposes? Or if you've got excess lease space, can you consider subletting unused lease space when people are back into the office or into their facilities, and other people may benefit and help you reduce your working costs, right? Another thing that people have looked at if they've got real estate assets is reborrowing, going to a bank, going to a lender, and reborrowing on the security of their real estate holdings because they perhaps may not have tapped the value in their real estate to give them security during to help them manage this difficult time. Similarly, in the same way you'd look at the real estate category of assets, you'd look at your other categories of assets. So is there any intellectual property that you have developed and is of value that you could license, whether it's brand, whether it's copyright, whether it's know-how, licensing it to others that you don't normally consider licensing it to in the jurisdiction or outside the jurisdiction? Asset sales. Are you one of those organizations that have gone into and run either a related business, or do you have investment assets, or do you have other non-core assets that are not maybe specifically necessary to manage your core mission, but have been an enhancement and an auxiliary thing that has been an important piece for the organization during regular times, but perhaps during a pandemic, an asset sale of these types of business assets or investment assets could give you the cash you need to sustain yourself during COVID-19. And finally, one area that people are looking at in an interesting kind of way now is integration. Lots of not-for-profit and charitable organizations will have considered mergers with other organizations with similar or compatible missions in the past. Now, people are looking at these defensive perspective. From a long-term view perspective, you can ensure the sustainability of your mission by growing in size. And that approach is entirely consistent with fiduciary duties of directors to look at the long term and say, how do we make sure that we can weather the next storm in addition to COVID? And the answer to that question for some organizations is that let's merge with other organizations that are compatible to us. And on a combined basis, we are larger, we are better equipped financially to weather financial distress, we are able to attract top talent because we'll be seen as more stable, and we'll be seen as having more opportunities available to staff and to directors, and we will benefit from economies of scale. We'll have efficient operations because a larger organization will have one IT system, not two IT systems, so on and so forth. And that will mean that dollar for dollar, we're going to be able to invest more of our money on programming and things that matter to the organization and less on back office administration. And so for a number of organizations who would have looked at mergers and integration transactions in the past without the lens of COVID, those discussions and those reviews are coming back to the front of the minds of boards senior management from a defensive position to say, hey, maybe now is the opportunity for 3 or 4 of us to get together, combine, and then on a combined basis, our balance sheet is going to be much stronger and will allow us to weather the storm and access different types of funding that we couldn't access before, and so on and so forth.
Thanks, Nick, for providing a great overview of some very important topics. I think you've certainly given us a lot to think about, and I look forward to hearing more, as I'm sure our listeners do, as the future unfolds, because I think these topics are going to be very important to many of us in the sector. So thanks again.
You're welcome. Bye for now.
I would like to thank all of our speakers, as well as BLG's business development and IT team who pulled this together. Thanks Ariana, Colin, and Kim, and colleagues Catherine Carr and Rima Sashadina, who did the bulk of the planning and organization for today. We hope you have increased your knowledge of the law that is relevant to your organization and appreciated you are taking time to be with us today. Please let us know if you have any feedback or topics for future sessions. And remember the many resources you will find on BLG's website around COVID and many other matters. You will be receiving an email with the slides and the recording. For those interested, this will qualify for CPD hours in BC, Quebec, and Ontario. Be well, everyone. We very much look forward to talking with you again soon. Take good care.